Have you ever stopped to think about what's really behind a corporate bond? Beyond just the company's promise to pay you back. Well, today we're going to pull back the curtain on this super important but kind of invisible piece of financial law, the Trust Indenture Act of 1939. Yeah, it sounds ancient, I know, but it's the very reason the bond market today is as stable as it is. Let's dig in.
So let's say you decide to buy a bond from some huge corporation. You're lending them your money. But what happens if things go wrong? If the company starts to struggle, who is actually in your corner fighting for your interests? Just you, all alone, against a corporate giant? It's a scary thought, and that's the exact question this law was created to answer.
Okay, here's our game plan. First, we're going to jump in a time machine and see what investing was like in the Wild West before this act. Then we'll look at the 6 huge problems that Congress found. After that, we'll meet the hero of our story, the trustee, and check out their rulebook. Most importantly, we'll see how this whole thing guarantees your right to get paid. And finally, we'll talk about why this old law is still a huge deal today.
So before 1939, the corporate bond market was, honestly, a total mess. It really was like the Wild West. When you bought a bond, you were pretty much on your own. If the company couldn't pay you back, well, good luck. There was no one organized to fight for your rights. You were just one person, lost in a crowd of other investors.
And this wasn't just a hunch. When Congress actually investigated this stuff, they didn't just find 1 or 2 issues. No, they pinpointed 6 specific, massive failures in the system that were putting regular people's money at serious risk. Let's walk through them one by one.
So, problem number 1, there was no one to speak for you. Think about it. If you owned a $1,000 bond and the company defaulted, were you really going to hire a team of lawyers to sue them? Of course not. It would cost way more than the bond was even worth. You and thousands of other investors were just spread out all over the place with no practical way to team up and fight back.
Now, sometimes there was this person called a trustee. Sounds official, right? Wrong. The contracts were often written to let the trustee off the hook for pretty much anything, even their own negligence. They were basically a guardian with no teeth. They had the title, but no real power, or more importantly, no real duty to help you.
And this one is a doozy. The trustee, the person who's supposed to be your neutral representative, could also be a lender to the very same company. So if that company had hard times, who do you think the trustee would look out for first? You, the bondholder, or their own loan? It was a massive conflict of interest, and investors were the ones who paid the price.
On top of all that, you were flying completely blind. Companies had zero obligation to tell you how they were doing financially. You could be holding a bond from a company that was secretly about to go bankrupt, and you would have absolutely no idea until your investment was worthless.
The contracts themselves, a total minefield. The indenture, which is the big legal document for the bond, could be packed with tricky language and fine print designed to strip away your rights. The whole thing was set up to benefit the company, not you.
And really, it all boiled down to this one simple fact. You had no power. The company issuing the bond and the big banks helping them, they wrote all the rules. You were just handed a contract and told, take it or leave it. There was absolutely no negotiation. It was a completely one-sided deal.
So, with these 6 huge problems making a mess of things, Congress finally had to step in. And the Trust Indenture Act of 1939 wasn't some tiny little fix. It was a complete overhaul of the system. And at the heart of its solution was a brand new, empowered figure, the indenture trustee.
The act basically said, from now on, for most big public bond offerings, you must have an indenture trustee. This isn't just some guy. It's a professional institution, usually a bank, whose entire job is to represent all the bondholders together. They become the single, powerful voice for thousands of different investors.
The easiest way to think about it is that the trustee is your professional watchdog. They're hired to sit on the porch and make sure the company is following every single rule in the contract. And if the company tries to pull a fast one or, say, miss a payment, the trustee is legally required to stand up and start barking. But see, the act didn't just create this watchdog role and call it a day. No, it gave the trustee a very clear, very strict rule book to follow. It laid out exactly who could be a trustee and what they had to do, which directly fixed those old problems of conflicts of interest and trustees who did nothing.
So, and this is really important, not just anyone can waltz in and be a trustee. The Act has a checklist. The trustee has to be a real institution, like a bank that's supervised by the government, and critically, it has to be independent. No more of those shady conflicts of interest that used to plague the system.
To make sure these trustees were legit, the Act even put a price tag on it.
They had to have at least $150,000 in capital. Now, I know what you're thinking. That doesn't sound like a lot today. But back in 1939, that was a ton of money. It ensured the trustee was a serious, financially stable institution, not some fly-by-night outfit.
Now, this is where it gets really interesting. The trustee basically has two different jobs. Before anything goes wrong, they're mostly just monitoring things, checking boxes. But the second a company defaults on its bond, a switch flips. Their responsibility totally transforms. The law says they have to act like a prudent person managing their own money. That's a huge deal. It means they can't just sit back. They have to actively and aggressively work to protect your investment.
So all of this stuff, the qualified trustee, the strict rules, the prudent person standard, it's all building up to one single essential guarantee. This is the absolute core promise the Act makes to every single person who buys a corporate bond.
And here it is. This is the magic sentence. It's your ultimate financial shield. What it means, in plain English, is that your fundamental right to get your principal and interest back on time cannot be taken away or changed unless you personally agree to it. A bunch of other bondholders can't get together and vote to change your deal. Your right to get paid is protected. Period.
So, why are we spending all this time on a law from 1939? Because every single day, right now, in the massive multi-trillion-dollar corporate bond market, this act is working silently in the background, providing the trust and stability that makes the whole thing run.
Think about it. It took on those 6 big problems, created a professional watchdog for investors, and, most importantly, guaranteed an individual's right to get paid. By doing all that, it completely transformed the bond market from a chaotic Wild West into a system people could actually trust. It's truly one of the unsung heroes of modern finance.
And that kind of leaves us with one last question to chew on. This act is a perfect example of a rule that works quietly behind the scenes to make our economy safer for all of us. So it makes you wonder, doesn't it? What other invisible rules are out there right now, protecting us in ways we don't even know?